Welcome back. Attorney Andrew Bethel here, ready to dive into even more taxes and finances, but this time we've got some good news. The IRS just released a critical update that could impact your financial and estate planning strategies, especially for those dealing with inherited IRAs. Today, we're dissecting the IRS's latest move to waive required minimum distributions, RMDs, for certain beneficiaries for 2024 under IRS Notice 2024-35. Don't forget to like and subscribe, share the video with a friend planning their own estate or if they've just inherited an IRA, and let's dive in. Let's get some quick background so we're all on the same page. In December 2019, the Secure Act dramatically altered how beneficiaries must handle inherited IRAs. Traditionally, beneficiaries could stretch distributions across their lifetime, thus minimizing tax hits with strategic distributions. However, the Secure Act introduced a 10-year rule compelling most non-spouse beneficiaries to fully withdraw these IRAs within 10 years of the original owner's death. There's a lot to unpack here as to who can avoid the 10-year rule and who can't, but I've already done a deep dive into inherited IRAs. The Secure Act introduced a 10-year rule compelling most non-spouse beneficiaries to fully withdraw these IRAs within 10 years of the original owner's death. Now, there's a lot to unpack as to who can avoid the 10-year rule and who can't, so I'll link to that in the corner. However, that brings us to IRS Notice 2024-35. This recent notice continues the trend set in previous years, waiving the 2024 required minimum distributions for specific IRA beneficiaries, particularly those not considered eligible designated beneficiaries, as in those subject to the 10-year rule. If you inherited an IRA from an IRA owner who passed away between 2020 and now, the time we've been under the Secure Act, and you were subject to annual required minimum distributions within that time period, then no penalties for missing those distributions this year. Now, let's tackle a complicated question. What happens if you're already taking RMDs from your own retirement accounts and you inherit an IRA? How do these requirements interact, and what strategies should you consider to minimize your tax burden? Great question, by the way. When you inherit an IRA, your required actions depend significantly on when the original owner passed away relative to their required beginning date, RBD, the deadline by which they must start taking their RMDs, which is currently April 1st, following the year they turn 73. If the IRA owner dies before reaching their RBD, you as the beneficiary are generally subject to the 10-year rule. Generally, no required yearly withdrawals, but you must ensure the entire account is emptied by the end of the 10th year following the owner's death. During this period, no annual RMDs are mandated, giving you flexibility in planning those distributions. The situation gets more nuanced if the IRA owner dies on or after their RBD. Here's how it breaks down. For non-eligible designated beneficiaries, we have rules similar to the first scenario. The 10-year rule applies. However, the key distinction remains the absence of mandated annual withdrawals, though the entire balance must still be distributed by the end of the 10th year. However, for eligible designated beneficiaries, which includes spouses, disabled individuals, and others closely defined by the IRS, the option to take distributions stretched over their lifetime is available. If the beneficiary is the spouse and opts to treat the IRA as their own, they'll adhere to the standard RMD regulations applicable to their age and circumstances. Again, go watch our prior video on inherited IRAs for more on eligible versus non-eligible designated beneficiaries. If you're already subject to RMDs due to your age or the specifics of your own retirement accounts, you must continue these withdrawals as required by law. For the inherited IRA non-eligible designated beneficiaries, you might opt to defer withdrawals from the inherited IRA to the latter part of the 10-year period, especially if you face years with lower income or if doing so could help manage your tax brackets more effectively. For the inherited IRA eligible designated beneficiaries, if taking life expectancy-based distributions, calculate your annual RMDs from the inherited IRA based on your own life expectancy, which is recalculated each year. This approach provides a steady stream of income while potentially smoothing out tax impacts. It's essential for beneficiaries who are managing both personal and inherited RMDs to consider their broader tax landscape. Large distributions can push you into a higher tax bracket, especially when combined with other income sources. Strategic planning, possibly spreading out IRA distributions across several years within the 10-year window, can significantly affect your tax liabilities. Just remember, beneficiaries subject to their own RMDs do not need to take RMDs from the inherited IRA unless they are eligible designated beneficiaries and choose or are required to take lifetime distributions. Otherwise, they can follow the 10-year rule. Of course, consult a tax advisor or financial planner to decide the best strategy for taking distributions in a way that minimizes tax liability and aligns with your personal financial goals. So why does this waiver from having to take RMDs from an inherited IRA matter to you? Well, if you're managing an inherited IRA, this waiver provides a temporary reprieve from the complexities of the 10-year rule, potentially deferring tax liabilities and affecting your overall financial planning. It's a significant relief, especially considering the potential spike in tax rates anticipated post-2025 when the current tax cuts under the Tax Cuts and Jobs Act are slated to expire. From an estate planning viewpoint, these waivers highlight the necessity for proactive and informed management of inherited IRAs. California residents in particular face unique challenges and opportunities in estate planning due to state-specific tax implications and the cost of living. First, strategic withdrawals. Even with waivers, consider the benefits of making voluntary withdrawals during your lower tax years to minimize the larger tax hit at the end of the 10-year period. Next, consult professionals. Engage with estate planning attorneys and tax advisors to navigate these changes effectively. Understanding the nuances of the IRS regulations and the Secure Act can ensure that you or your beneficiaries' financial futures are secured and penalties are avoided. Then, long-term planning. Look beyond the immediate tax relief. Plan comprehensively for the distribution phase, keeping in mind the eventual depletion of the account by the 10th year following the IRA owner's death. As we wrap up, remember the IRS's ongoing adjustments to RMD regulations underline the dynamic nature of retirement and estate planning. Staying informed and adaptable is crucial. Have you or your family been affected by these changes? What strategies have you found beneficial in managing inherited IRAs? Share your thoughts in the comments below. Remember, proactive planning and professional advice are your best tools in navigating these changes. I'm attorney Andrew Bethel, and I'm here to help you make sense of the complex laws that impact your estate planning and financial planning. And I'll see you at our next meeting.